I've still got this fire inside my heart. Though the battle's far from over, I'm still getting stronger. And I'm still in the fight. I've been knocked down, but I'll be alright. And I'm still by your side. May seem broken, but I'm whole inside. I'm still here, I'm still in the fight. When said it wouldn't be easy, there's still those who need me. I won't be the one to let them down.
The first one, actually, Your Honor, is relevant to the first contempt proceeding that prosecutor indicated she wanted to move on. And this is a renewal of a motion to dismiss for denial of the right to a speedy trial. And this is under the Barker versus Wingo test, Judge, which you know, of course, is the test for a speedy trial denial here in the state of New Jersey. And simply stated, the delay that the prosecutor took, and Your Honor may, I don't know what procedural history, Your Honor may be more familiar with the procedural history than I am. But all I know is that there was previously an issue raised with respect to the motion with respect to speedy trial, and ultimately it was before Judge Schlosser, and Judge Schlosser indicated essentially indict or dismiss, A or B, and the prosecutor took C,
which was they remanded it.
Which was to remand to a disorderly persons offense. Our TRO that was signed against you as well, shortly after this.
Objection, relevant.
Goes to bias and interest, Your Honor, appropriate cross-examination.
I'll give you a little leeway.
I'll be very quick.
All right.
I'll be very quick. It was a TRO that was also issued against you.
Correct.
And that TRO indicated that your weapon should also be seized.
That's not correct.
The TRO itself indicated your weapon should be seized, correct?
No, it did not.
Okay. I'd like to mark this defense exhibit 5.
Can't they? Let's see. No, D. Oh, D. Wait a minute. Yeah, she may be right.
She's right.
Yeah.
May I approach, Your Honor?
Yes, ma'am.
I'm going to show you what has been marked as Defense Exhibit 5 and ask you if you recognize this, and I'm going to direct you to the last page, which shows Judge Bell's signature and the date of 2/9/99.
Okay.
Do you see Judge Bell's signature?
Is this here?
Yes?
Mm-hmm.
And do you see in the page just before it it indicates, and the box is Xed, any law enforcement ever having jurisdiction in this order shall serve as a warrant to search for and seize any issued permit to carry a firearm.
Sir, I'm going to stop you right here. Would you ask her to identify what the document is for purposes of the record, please?
Okay, I'm sorry.
I know what it is.
Okay.
Record doesn't.
Okay. The front of it indicates a New Jersey domestic violence civil complaint and temporary restraining order, correct?
Yes.
Okay. And we identified the last page as Judge Bell's signature on it, correct? And the next to last page in the box indicates that jurisdiction is granted to search and seize a weapon, and specifically there's written in a specific description of a weapon, which is your service revolver, correct? A Smith & Wesson .40 caliber.
That's correct.
But that was never seized, correct?
Actually, this isn't on my copy of my restraining order. This is a
Just answer my
Xerox
question.
copy.
That was never seized from you, is that correct?
No.
Okay. Your father is the president of the Burlington Township Council?
No, that's not
We're
correct.
going a little far
I
afoot
have
here.
nothing further. May I approach, Your Honor?
Yes, you may.
Showing you, it's been marked as Defense Exhibit 6. Are you familiar with the Burlington County Prosecutor's Office operational directive with respect to domestic violence incidents involving police officers and correctional officers?
Maybe not this particular copy, but I'm aware of it.
Okay. I want to direct your attention specifically to Roman numeral 5. Procedure to be followed when either a police officer or a correctional officer is an accused in a domestic violence incident. You see that section?
Yes.
And it says, in all situations where an officer has been alleged.
Where are you reading from?
Roman numeral 5, capital A. In all situations where an officer has been alleged to have committed an act of domestic violence, all weapons, both duty and personal, shall be removed from that officer's possession, in accordance with 2C 25-21. What it says, doesn't it?
Yes.
Nothing further. And the next to last page in the box indicates that jurisdiction is granted to search and seize a weapon, and specifically there's written in a specific description of a weapon, which is your service revolver, correct? A Smith & Wesson .40 caliber.
That's correct.
But that was never seized, correct?
Actually, this isn't on my copy of my restraining order. This is a
Just answer my
Xerox
question.
copy.
The line of questioning is relevant for purposes of addressing the motive and intent of the witness in saying something other than the truth, which is obviously also always a proper cross-examination. With respect to the cross-examination vis-a-vis the policies of the Burlington County law enforcement and the prosecutor's office concerning, again, the seizure of weapons in domestic violence orders involving police officers. Again, the same purpose was to confront the witness with the fact that her weapons were not confiscated when my clients were, to develop what is an appropriate line of cross-examination with respect to any witness, and that is the motive and intent of that witness to color her testimony, in this case, to be more harmful to the defendant than is accurate. And I would also point out that neither one of the motions are timely, in that they should have been made at the time. They're not being made at the time. The whole purpose of the continuance was, in fact, to prove me factually wrong. That did not come out of Ms. Mishaw's mouth, which, frankly, as I indicated, what is most of the time most important in finding the truth is not what is said, but it was not said. And the fact that she did not say that, I think, confirms the fact that, in fact, the order was as I described it, and as I confronted the witness with it. And that is so confirmed with what was sent to me, and the tape, in fact, that was also sent to me. So for all of those reasons, I believe it was appropriate cross-examination, and I ask Your Honor to find not only that the objection is not timely, is not why we continued the case, but also has no basis in fact or law.
But I tend to give people leeway when it comes, give counsel leeway when it comes to cross-examination, so he can ask those questions. Please, I hope we're not going to put internal Burlington County Prosecutor's Office's procedures on trial here, because it's not really relevant as far as this court's concerned as to whether in fact there was a violation of a restraining order. Ms. Mashad.
Yes, Your Honor. Before we commence, Your Honor, I am moving to strike certain testimony. The state had objected to testimony relating to the victim having his TRO, a temporary restraining order, signed against her. I object on relevance ground that there was continued questions into whether or not there was to be weapons seized. While the court overruled the objection with respect to the whether or not a temporary restraining order was issued, the specific provisions, specifically the weapons issue, is not relevant to the issue of, it's not relevant to this case. The grounds for admitting the testimony was that it showed bias. What specific provision is checked off does not further demonstrate that bias. In addition, on cross, there was questioning relating to the Burlington County policy for law enforcement officers involved in domestic violence, and again, that was referencing questions relating to the seizure of weapons when law enforcement officers involved in domestic violence in reference to the victim. Again, first, that was not the subject of redirect, so it is beyond the scope of redirect. In addition, it's irrelevant to the issue that we're here today before this court. The issue is whether or not Mr. Baranowski knowingly violated domestic violence restraining order by possessing a firearm, and while bias may be relevant, those details are not. I'd suggest to the court that when we began this trial, defense counsel filed a motion to dismiss based upon selective prosecution. And I suggest to the court that by asking those questions, the defense is trying to lay the groundwork for those issues in an appellate proceeding, if we get to that point, without the state having the opportunity to present its answer to that allegation. And the testimony that the state has just cited is not relevant to any of the issues of this trial, so I would move that that testimony be stricken.